Garrett.
Thank you, Mr. Speaker. My question is to the Attorney-General and asks, where in the marine and coastal area, bracket Takutai Moana, close bracket bill, is it guaranteed that access to beaches held under customary title will be free?
The Honourable Chris Finlayson.
Mr. Speaker, the whole scheme of the bill prohibits charging for public access. I invite the member to look at Clause 27, which guarantees public access to the common marine and coastal area. Clause 60, which specifies that customary marine title exists in a particular part of that area. Clause 63, which sets out the scope of rights which may be exercised by customary marine title holders, and Clause 64, which specifies that those rights do not include charging for public access. The only restrictions on public access in the area are the reasonable ones which already exist, for example, picnicking at ports, fly fishing off naval bases, or beach cricket on burial grounds.
Materia Ture.
Thank you, Mr. Speaker. Can the Minister guarantee public access to the foreshore areas currently held in the 12,500 private titles?
The Honourable Chris Finlayson.
The position with the 12,500 titles remains what it was when the 2004 Act was passed. They are private titles and we are dealing with other areas of the coastal marine area.
Supplementary.
Materia Ture.
Thank you, Mr. Speaker. How does the Minister justify legislating for public access to foreshore held in Māori customary titles, but not that held in those 12,500 private titles? Why the discrimination, Minister?
The Honourable Chris Finlayson.
There's no discrimination. It recognises, and this was the case in the 2004 Act as well, that there are private titles for various reasons in the coastal and marine area. Those titles include land held as Maori customary land, freehold titles held by both Maori and Pākehā.
David Garrett.
Speaker, if Maori owners under customary title do start charging for access or restricting access to the foreshore and seabed, what penalty is there in the new law to stop them from doing so?
The Honourable Chris Finlayson.
I've already said that it's not possible to do so. Any attempts to deal with that situation will be dealt with by the Minister of Conservation, who will have adequate powers to deal with those sorts of problems.
Te Uraro Flau.
Tēnā koe, Mr. Speaker. To the Minister, has he seen the comment from Ngāti Porou leader Dr. Āpirana Mahuika, same person, who says, quote, my advice to the Māori Party is to persist with the repeal because all iwi want a repeal of the Act so their mana can be assured by the Crown and that their mana be inalienable, unbroken and sustainable, end of quote. And how well does the Marine and Coastal Area Takutai Moana Bill respond to this advice?
Honourable Chris Finlayson.
Mr. Speaker, no, but like so much of what Dr. Mahuika says, it seems to be very sound advice. The mana of iwi and hapu is explicitly recognised in the bill. It provides for a recognition of tupuna or ancestral connection to the coastal area. It contains an acknowledgement of the mana-based relationship of iwi and hapu to the marine and coastal area in their rohe.
Supplementary, Mr. Speaker. Does the Attorney-General agree with Māori Party MP Te Uraroa Flavel that, quote, another go, close quote, may be required, and if not, can he categorically rule out extending the time available for claims from 6 years while he is the Attorney-General?
The Honourable Chris Finlayson.
Well, the limitation period is 6 years. That's what the government thinks represents a fair balance of all rights. As to whether or not I agree with Mr. Flavel, he's an excellent MP. It's great to work with him so that we can get rid of this disgraceful 2004 Act.
The Honourable David Parker.
Does the Attorney-General agree with the Prime Minister that the proposed legislation should settle the legal framework for foreshore and seabed claims?
The Honourable Chris Finlayson.
Well, of course I do. He's the Prime Minister and he's always right.
The Honourable David Parker.
Given his belief that the legislation should settle foreshore and seabed issues, Is he concerned that Māori Party acting leader publicly stated yesterday that, quotes, "we will certainly be looking at it again," quote, end quotes, and their quotes, "will be another time for our people to come back and have another go in the future"?
The Honourable Chris Finlayson.
I know this is probably an alien concept to the Labour Party, but that's democracy.
Point of order, Mr. Speaker.
Point of order. A point of order has been called. The Honourable David Parker.
A point of order. In response to my prior question, he agreed that this should be the legal framework for setting claims, and my question was quite simple. Was he concerned by the Māori Party saying that they'll have another go? That didn't address that question.
Well, I think the order, a point of order is being considered. The Minister in answering it said, well, that's democracy, and I imagine he was indicating that it's impossible to bind what future parliaments might consider doing.
Supplementary.
Point of order, Mr.
Point
Speaker.
of order, the Honourable Trevor
Mr. Speaker, if that's what the Attorney-General had said, and all he had said, I think there'd be people on the side will not be happy, but I think there wouldn't have been a breach of standing orders. I invite you to maybe afterwards have a look at what he did say and said in particular about a party on this side of the House and whether in fact that was conducive to good order.
I hear order. The member's point of order is fairly made that if a minister is going to give an answer that's perhaps on the margins of being acceptable, they shouldn't preface it with a criticism of the questioner's party. It's probably a bit late for me to go back on this one now, but I just warn the Minister, if the Minister's going to give an answer that is marginally acceptable, don't preface it with that kind of comment. The Honourable Trevor Mallard's point of order is perfectly well made.
Supplementary.
The Honourable David Parker.
Does he agree with the Prime Minister's statement earlier in the year, and I quote, "In the end, if we can't reach an agreement, then the status quo will remain"? And if so, does the government intend to seek an acknowledgement from the Māori Party that it will accept the legislation settles the issue, and if they won't give that assurance, will the status quo remain?
Honourable Chris Finlayson.
Well, again, as to the first part of the question, of course I do, because the Prime Minister said it.
Te ora o Flavel.
Mr. Speaker, to the Minister.
Te ora o Flavel.
To the Minister, does he agree with Hokianga Elder Rudy Taylor in his comments regarding the Marine and Coastal Area Takutai Moana Bill that Māori have always shared the coastline with their Pākehā neighbours and it is absurd to suggest that that will change? And if so, what does he think will be the key impact of the racially divisive campaign promulgated by the Coastal Coalition?
Honourable Chris Finlayson.
Speaker, I strongly agree that there's a culture of welcoming people, of sharing, of hospitality that pervades Māori culture, and it's always been my experience, whether visiting iwi to discuss the government's proposals this year or going out on the road to discuss settlement of historical treaty grievances, and I can understand why they get excited about that proposition because they never did it.
Question number 4, the Honourable David Cunliffe.